This is the statutory guidance on the Terrorism Protection of Premises Act. It's 127 pages long. We've read it, so you don't have to. And these are all the points that we think everyone needs to know about the Act. Under the Terrorism Protection of Premises Act, the responsible person for a site in scope needs to be able to show to the satisfaction of a regulator, if they are inspected, that they've put in place public protection procedures so far as is reasonably practical. Therefore, documenting said public protection procedures and the evidence that they've been tested and tried and trained to their staff is necessary to enable to show compliance. In the statutory guidance, there are 3 terms that you need to pay attention to when looking at the Terrorism Protection of Premises Act. First term, must. This is a legal requirement in the Act. Second term is should. This is not an express requirement in the Act, but strongly recommended and encouraged good practice, and may be required to be seen by the regulator to show that you're doing everything that's reasonably practicable to do. And lastly, could. This is again not a legal requirement, but it's an optional suggestion or example to enable you to reach full compliance. Within the statutory guidance for the Terrorism Protection of Premises Act, it discusses specifically what public protection procedures are, these being an evacuation, invacuation, lockdown and communication plan. An evacuation plan is the process of getting people away from danger by moving them out of the premises or event as quickly and as safely as possible. This is different to a fire evacuation plan because we're trying to move people away from an assailant and not necessarily out of every single exit. These can be found in Figure 7 of the statutory guidance. An evacuation plan is the process of moving people away from danger to a place within a premises or event where there is less risk of physical harm. You tend to find evacuation plans will be enacted when an assailant or assailants are close by to your premises or about to breach the exterior of the premises. Again, this can be found in Figure 7 of the statutory guidance. A lockdown plan is the process of securing the premises or event to prevent individuals entering or leaving. You tend to find this being enacted when an assailant is inside your site or inside your premises, and the safest course of action is to stop people from moving and barricade themselves in where they are. This again can be found in Figure 7 of the statutory guidance. A communication plan under the statutory guidance, the Terrorism Protection of Premises Act, is the process by which you communicate all other procedures to all personnel on the site. This needs to be clear and effective to ensure that your intent can be followed easily in the event of a terrorism incident when clearly a lot of activity will be going on. Again, this can be found in Figure 7 of the statutory guidance. That's the 4 public protection procedures which are explicit under the legislation. Now let's explore some of the implied tasks falling out from this requirement. So one of the primary differences between the standard tier and enhanced tier, for any site that's in scope of legislation, you require public protection procedures, these being evac, invac, lockdown, communication plan. Under the enhanced tier, you may also require public protection measures. Measures are split into 4 further categories, these being monitoring, movement, physical security and security of information. These need to be implemented so far as is reasonably practicable and then evidenced and a rationale as to why they've been implemented and what reduction to vulnerability they give to the site or to anybody on the site from physical harm if there was a terror incident occurring on that site. The Act requires the responsible person to put in place public protection procedures so far as is reasonably practical. Reasonably practical is a term derived from health and safety legislation. What it requires is organisations or responsible persons for those organisations to assess, looking at the nature of their site, the resources available to them, and the cost, time and effort of putting in place public protection procedures. As shown in the statutory guidance, the likely effectiveness of any particular procedure weighed against the burden of its implementation in terms of cost and feasibility. Under the standard tier of the legislation, those sites that are in scope or the responsible person does not have to submit evidence to the regulator of compliance with the legislation. They only need to show that they are in scope. However, if you are inspected at any point and you are unable to evidence your compliance or the steps you've taken towards compliance, this may result in financial penalties. Prova Risk enables sites with no prior terrorism risk training to make an assessment and justification for what is reasonably practical for their site to evidence this for the satisfaction of the regulator. Under the Terrorism Protection of Premises Act, there is no specific requirement to train staff. However, As part of ensuring that public protection procedures are in place and can be enacted quickly and effectively, those working at the premises with responsibility for carrying them out, as identified by the responsible person, must be made aware of the procedures and their specific role. If staff who are responsible for carrying out the procedures are not informed of those procedures or trained in how those procedures should be implemented, it is likely to be difficult for the responsible person to demonstrate that appropriate and reasonably practical procedures are in place. As evidenced in the statutory guidance in 3 different summaries and under the Terrorism Protection of Premises Act, if your premises or event sits within a larger premises, or you are co-located or share a premises with another organisation, you must make sure that your public protection procedures and/or measures dovetail with that other organisation and that you work in conjunction with them to ensure a seamless enactment of any public protection procedures. Under the Terrorism Protection of Premises Act and as defined in the statutory guidance, every site in scope will have a responsible person. The responsible person is an individual or entity that has control of or legal responsibility for the site in the context of its primary use. As defined in the statutory guidance, the responsible person can delegate tasks to other individuals, but not responsibility. Therefore, the responsible person, whether it be an individual or entity, must ensure that all public protection procedures and/or measures have been put in place so far as is reasonably practicable. Under the Terrorism Protection of Premises Act, the regulatory body is the Security Industry Authority, or SIA. All sites under the Act need to tell the SIA that they're in scope, if they deem that they're in scope. They need to give them the details of their site, and they need to tell them who the responsible person is, be that an individual or entity. For those sites that are in the enhanced tier, they also have to detail the public protection procedures and public protection measures that they put in place. They have to detail if there is a senior individual that's been designated with a responsibility within the organisation and the details of that individual. And they need to give them an assessment on why the public protection procedures and/or measures that they've adopted will reduce the vulnerability of the site and the people on the site to an act of terrorism or to physical harm from an act of terrorism. The Prova Risk platform creates a compliance document, so if the regulator does ever ask to see all your public protection procedures so far as is reasonably practical, you can show them all public protection procedures, your training records, your exercise records, and all other relevant material that the regulator may wish to see. If you're in the standard tier, the maximum penalty that you may face is up to £10,000 per premises. If you're in the enhanced tier, that jumps considerably to £18 million or 5% of the responsible person's qualifying worldwide revenue. The Prova Risk platform is designed to ensure that you can show compliance as quickly, simply and cost effectively as possible to avoid any financial penalties from the regulatory body, the SIA. The Terrorism Protection of Premises Act gained royal assent in April 2025. The government gave a minimum 24-month grace period before compliance was going to be required under the Act. The statutory guidance was published in April 2026. Compliance is expected to be required by April 2027. Organisations can ensure that they reach compliance by utilising the Prova Risk platform. This enables them to put in place all public protection procedures and/or measures as quickly, simply and cost effectively as possible, ensuring they are compliant by the compliance deadline. If you want to get started on your compliance journey, head over to provarisk.co.uk, click the Get Started button and start your compliance journey with Prova Risk.